Trust created for the benefit of a child or a descendant who has a disability are often referred to as special needs trusts. But what happens when that beneficiary passes away? The answer is largely going to depend on the type of special needs trust that's being created. When parents proactively plan ahead with their own estate plan to create a special needs trust to pass on wealth through inheritance to a child who has a disability, we call that a third party special needs trust. And it's because it's being funded by a third party, someone other than the beneficiary themselves. Medicaid does not have an interest in that type of structure, and so they do not need to be paid back at the death of the beneficiary. And so in a third party special needs trust, we're able to name remainder beneficiaries. It could be other children of ours. It could be other family members generally, or even charities or nonprofits that we want to provide a benefit to. But it's anybody other than Medicaid. When we react to an inadvertent inheritance or a gift or a personal injury settlement, we have to create what's called a first party special needs trust. First party means it's being funded with the beneficiary's own money. And in these types of trusts, there is a Medicaid payback provision. And so at the death of a beneficiary of a first party special needs trust, the remaining balance has to first pay back Medicaid for services used or provided to the beneficiary during their life before being paid to any remainder beneficiaries.